Hello, my name is Maureen O'Neill. I'm a partner in the EU and Antitrust Group at Mason Hayes & Curran. We've been involved in a significant number of the merger notifications made to the Competition Authority in this jurisdiction over the last few years. Now, the Irish merger control regime is fairly well bedded in at this stage. It's been in operation in its current iteration since 2003. However, in our experience over the last few years in particular, we've noticed a number of practices of the Competition Authority that I thought worth sharing with you and are well worth knowing about, especially if you are likely to be making a notification to the Irish Competition Authority. Now, you should have access to slides that go with this presentation, so you'll be able to follow me along as we go through. What I plan to do today is to take you through the highlights of the Irish competition regime, just by way of reminder really, and to set the scene of what I would like to discuss in a bit more detail with you. We'll take a quick look at recent trends in the Irish merger control regime. And then I'd like to take you through some of our recent on-the-ground experience of dealing with the Competition Authority in some of the more complex notifications that have come up in the last few years. Now, I think it's fair to say that the Irish merger control regime punches above its weight in the context of international transactions. There are a number of reasons for this. First of all, the thresholds under the Irish Competition Act are relatively easily met. Really, you only need one party to the transaction to have a significant presence in Ireland for the Competition Authority's jurisdiction to be triggered. And as long as another party to the transaction has some presence in Ireland, and that could be just by way of sales and turnover rather than a physical presence, then you're likely to be into the realm of the Irish competition regime. Really, though, the sucker punch in terms of the Irish merger control regime is the fact that there can be criminal sanctions attached to a failure to file in this jurisdiction. Now, you'll see from the slides that the criminal sanctions, the penalties themselves in terms of fines, aren't eye-watering by any means, especially when you compare them to the types of fines that we're used to reading about in terms of European Commission investigations, be that merger control or indeed general antitrust fines. However, the point is they are criminal in nature. And I have to say, I've yet to come across a company executive or a member of a board who is happy to take a view on whether or not a filing is required in a particular jurisdiction if there is a risk of a criminal conviction if they get that call wrong. It's also worth pointing out that under the Irish regime, unlike under the EU merger control regime, parties must file within 1 month of the signing of a final agreement. So unlike the EU merger regime, where you can file whenever you like, really, as long as you haven't completed the transaction before you get clearance, with the Irish regime, you must file within 1 month. Now, that generally doesn't present an issue because in most transactions, the party's concern is to get the transaction notified as quickly as possible. However, there are circumstances where the fact that an Irish filing has to be made may not be identified early on, and indeed may slip through the net, and the parties only realise perhaps after that 1 month deadline. And that gives rise to significant concerns on the part of notifying parties, because technically then they are in breach of the Act and with the potential of attracting criminal penalties for failing to file within that timeline. Also, it's worth flagging and reminding you that it is not possible to notify the Competition Authority of a transaction unless and until you have a final signed agreement. So again, unlike the EU MR regime, you cannot file on the basis of a letter of understanding a letter of intent or a memo of understanding. And again, that sometimes presents problems for parties who are trying to front end the whole merger approval process, where in most jurisdictions nowadays it is possible to get clearance in advance, possibly in advance of signing, and certainly to kickstart that process well in advance of completion. And we have found that sometimes causes concern and confusion sometimes with clients. Finally, it's worth mentioning again that in a phase 1 investigation by the Competition Authority, they have the power to issue a formal information request where they require additional information from the parties. In that case, where a formal information request is made to the parties, the clock stops on the authority's 1 month review period. And not only does the clock stop, but it is also reset to 0. And it doesn't start again until the parties have submitted their response to the RFI. Now, these last few factors, the fact that there is, it's not possible to notify in advance of having a final signed agreement, and the risk that the clock could be stopped and reset. I found in my practice certainly that sometimes pushes parties to consider the possibility of carving out Ireland from a global closing. I'm going to come back to this later in a bit more detail, but I just flag here that the authority is taking an increasingly dim view of that practice. I'm going to just remind you of the thresholds under the Competition Act, the Irish Competition Act. Now, a transaction is notifiable to the Competition Authority if in the most recent financial year the worldwide turnover of each of at least 2 of the parties to the transaction exceeds €40 million. We also need that the turnover in the Republic of Ireland of any one of the parties, so we just need one of the parties for this particular threshold, is not less than 40 million. And then at least 2 of the parties to the transaction must carry out business in any part of the island of Ireland, and any part of the island of Ireland meaning the Republic of Ireland and Northern Ireland. Now, I'm going to come back a little later to this carries on business test in the context of recent practices of the Competition Authority that I'd like to talk to you about. But we can just leave the thresholds at that. As I said, I just wanted, by way of reminder, to give you sort of a high-level reminder, as it were. You'll see from your slide pack that I've set out the statistics of notifications to the Irish Competition Authority since 2003. Now, you see the high point of filings, and we had 98 filings before the Competition Authority in 2006. Now, that fell dramatically in from that period, 2006 to 2009. And in 2009, we had an all-time low of 27 notifications. Now, it's going to come as no surprise to you that those high points and low points coincide to the rise and fall of the Celtic tiger here in Ireland. You'll also see from your slide pack that I flagged the 2 recent Phase 2 cases that the Competition Authority has investigated. Now, Mason, Hayes and Curran was involved in these two Phase 2 cases, and indeed they're the only Phase 2 cases that the Competition Authority has investigated since December 2010. Now, I'm not going to go into detail on the substantive analysis of these cases because because that's beyond the scope of this presentation, and where I want to focus on recent practices rather than substantive issues. But I have included on the slides some details and references if you do want to look into those in a bit more detail. So I'd now like to move on to our recent on-the-ground experience of the Competitions Authority's practice in merger cases. There are three things that I'd like to talk to you about. The first is certificates of compliance, which are issued in the context of formal requests for information when they are issued by the Competition Authority. The second is the carries-on business test, which I referred to earlier in the context of the jurisdictional thresholds under the Irish Competition Act, I should say. And finally, to take a look at gun jumping, where parties implement a transaction in advance of getting clearance from the Competition Authority, and the increasing publicity surrounding such instances where they come to light before the Competition Authority. Now, first of all, certificates of compliance. What are they and why do we care? Certificates of compliance are now issued as a matter of standard practice by the Competition Authority when a formal request for information is issued. And the parties are required by the Competition Authority to submit the certificate of compliance with their response to the request for information. Now, what the certificate of compliance seeks to do is to confirm to the Competition Authority that the request for information has been complied with, and that whoever is signing the certificate of compliance understands the sanctions that are applicable for failure to comply. What are the sanctions? Well, interestingly, the sanctions for failure to comply with a formal request for information are criminal in nature. Now, the criminal aspect of this sanction only kicks in if a person who is in control of the undertaking, of the relevant undertaking, has knowingly and willfully breached the provisions of the Act. Now, that can be quite a tough standard for the Competition Authority to prove in the ordinary course. However, in a scenario where an officer or an executive of the company has signed a certificate saying the company has complied with the request for information and I understand the sanctions for failure to comply, that must give the Competition Authority, in my view, some evidentiary weight in terms of proving a breach of the Act. Again, like before, I have found that company executives and board members tend to get a little uncomfortable when they're being asked to sign something in relation to which there is a risk of criminal sanctions if they get it wrong. What we have done in the past in a number of cases, and I should say here, this doesn't seem to be the practice across the board, but we have found that it is possible to amend the authority's standard certificate of compliance. So what it says generally, as I said before, is that X company has complied with the request for information. What we have done is to amend the certificate to say, so that the person signing the certificate is saying that X company has, to the best of my knowledge and having carried out reasonable inquiries, complied with the certificate, with the request for information. As I said, we've submitted amended certificates of compliance to the Competition Authority in 3 cases, and we have never had any pushback from the authority on this. And we've certainly found, from our client's perspective, that it is much more palatable to sign a caveated certificate of compliance than an open-ended one. The second practice that we've had some experience of recently and that I'd like to bring to your attention is the carries-on business test. as you recall from earlier, I mentioned that the third limb of the thresholds, the jurisdictional thresholds under the Competition Act, requires that at least two of the parties to the transaction carries on business in the island of Ireland. Now, this in the past caused considerable uncertainty for parties. They weren't quite sure what this meant. So the authority issued guidance and explained that they understand the carries on business test to mean that the relevant party, has a physical presence on the island of Ireland, and by physical presence they refer to a registered office, a subsidiary, a branch, a representative office even, or agency. But in addition to the physical presence, the company must also have made some sales or supplied services to customers on the island of Ireland. The other alternative test is that without having a physical presence on the island of Ireland, the party has made sales or supplied services of at least €2 million in the most recent financial year. Now, just to go back to the first limb of the guidance for a moment, and to flag to you that the physical presence, where it's not enough for a company to have a physical presence to meet this requirement, there must be a physical presence and some element of sales. Now, it is generally recognised by practitioners in this jurisdiction that even a minimal amount of sales, so even below that 2 million threshold that's in the second limb, would be sufficient, but nonetheless there must be some element of sales to trigger that requirement, or at least that had been the understanding of how the authority interpreted the carries on business test. Now, notwithstanding the authority's own guidance on this, which I've just mentioned, recent experience suggests to us that the authority appears to consider that it has some margin of discretion in how it interprets the carries on business test. You'll see from the slide pack that I refer to the Royalty Pharma Elan case, which is a recent case in which we were involved. Again, you see from the slides, it was very obvious that Royalty Pharma met the three thresholds. It had worldwide turnover in excess of 40 million, so tick box. It had turnover in the Republic of Ireland of over 40 million, so tick box. And consequently, it also satisfied the carries on business test, as it had turnover, regardless of physical presence, of over 2 million in the island of Ireland. Elan, however, was a different story. Now, it did have worldwide turnover in excess of 40 million. However, while it had a physical presence on the island of Ireland, for the last financial year, it actually had no turnover whatsoever. Nevertheless, the authority considered that its jurisdiction was triggered and the carries on business test was met. And it seems to have come to that conclusion by virtue of Elan's iconic status in this jurisdiction. It's a large company that is headquartered in Dublin, and up until about mid-2011 was a significant employer of people in the Midlands of Ireland. And it seems that the authority was just not prepared to accept that a company like that did not carry on business in the island of Ireland. Now, from a practical perspective, this is probably not going to impact very much on people's assessment of whether or not they trigger a merger filing requirement under the Irish merger rules. However, in marginal cases such as this, it does suggest that parties need to be quite careful, and it may well be prudent to approach the competition authority to seek informal guidance as to whether or not the carries on business test is met in light of its own guidance and recent practice. Finally, I'd like to say something about gun jumping and the approach of the Competition Authority as that has crystallised over the last few years. As I said in earlier remarks, under the Irish competition regime, it is not possible to notify a transaction to the Competition Authority until you have a final signed agreement. And given that, along with the fact that there is always a risk that the clock will be stopped if the Competition Authority issues a formal information request, we have found in our practice that this tends towards parties looking for ways to carve Ireland out of global closings where the deal timetable becomes an issue as a result. Where a transaction has been notified to the Competition Authority and the parties go ahead and implement the transaction in advance of the standstill provision under the Competition Act, which requires parties to wait to implement until they have had clearance. Where that is breached, there is no fine and no penalty. The transaction itself is deemed void, but other than that, there is no sanction. Now, again, I am assuming here that the transaction has been notified. So we're not talking about here a breach of the notification requirement. We're talking about a breach of the standstill provision. And in those cases, the only sanction is voidness. And the authority, it's clear from authority statements over the years that the authority considers that that voidness is actually cured if and when it clears the transaction. And this means, this has meant that parties have considered Ireland to be quite a low risk and attractive prospect in terms of carving out. In that context, however, it is worth considering the authority's practice in relation to, or its attitude towards gun jumping, which has crystallised relatively recently. Now, to date, there have been about 8 decisions by the Competition Authority, clearance decisions, where it has identified that the parties have engaged in gun jumping. But to date, it has adopted different approaches to that practice, and you'll see in the slide pack that I have set out a table listing the transactions where we have identified that gun jumping was an issue and noting the authority's approach. To date, it's only in the Stena DFDS transaction where the authority actually issued a press release in advance of its clearance decision, and in quite a strongly worded statement criticised the parties for implementing the transaction in advance of clearance. More recently, however, the authority has amended its communications policy to make clear that going forward, in future cases where in its opinion the parties have implemented a transaction in breach of the standstill obligation under the Competition Act, they will issue a press statement in advance of clearance. Now, it remains the case that there would be no sanction other than voidness in such a scenario, though we'll see if that remains the case, because the Competition Authority is agitating for change in that regard and for bringing in legislative changes which would see significant penalties for such practice. However, at the moment, we're in a scenario where there are no fines or penalties. But regardless, it should be borne in mind that the negative publicity of a competition authority publicly stating and condemning parties to a transaction for breaching a standstill provision of the Competition Act is not an attractive prospect. I'm going to leave you there, and to thank you very much for your attention. Obviously, if you have any questions or queries on Irish merger control, or indeed any antitrust or regulatory issues, please don't hesitate to give me a call. My contact details are on the final slide of the slide pack that you should have to hand. Thank you very much.